Welcome to Rebel Chaser. My name is Gail, and I've got a video for you from Judge DeSanto in Michigan. And all I can say about this one is, wow, really? That's the kind of case it is. I'll let you watch.
Let's go on the record in the matter of the state of Michigan versus John Pruitt II.
One grant my plate, 35143 on behalf of Mr. Pruitt. Thanks to my right.
Good morning. And sir, your name for the record, please.
John Pruitt II.
All right, thank you. Today's the date scheduled for the adjourned pretrial in this matter. And counsel?
Your Honor, at this time my client is going to enter a plea of guilty on the grounds of contempt for
All right. Sir, please raise your right hand. You solemnly swear or affirm testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Okay. You heard the plea that was placed on the record, correct?
Yes, Your Honor.
As to the charge of domestic violence, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand that by entering into a plea, you'll be waiving some of those rights.
Yes.
Do you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
Yes.
You also understand what the 769.4A status is.
Yes, Your Honor.
And that if you're eligible, the court would likely assign that eligibility to you. Do you understand that?
Yes.
You also understand, sir, the recommendation is probation, alcohol assessment and treatment, anger management, no contact, and any additional conditions set by the court. Do you understand that?
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Counsel, if you could, I'm sorry, any immigration issues?
No.
Counsel, if you can please refer to your client.
Yep. Mr. Pruitt, was it October the 12th, Your Honor? On the 14th. 12th or 14th?
12th.
Okay. The city of Riverview. You were there, correct?
Yes.
And you were at your home with your wife at that time, correct?
Yep.
There was an argument between the two of you,
Yes.
and she indicated to you that she wanted a divorce.
Yes.
And you took off your wedding ring and threw it towards the dresser, and she was near the dresser, correct?
That's correct.
Satisfactory. That's the allegation. That the ring was the throwing of the ring was unsolved.
Okay, well, how close was your wife to the dresser?
It's like a 6 foot long dresser. To be honest, I was packing a bag going to my dad's house, and I just took it off and was just like, "Here, you can have it," and just threw it at the dresser.
She says he threw it at her.
Well, counsel, I'm not hearing a factual basis to accept the plea. So,
yeah,
I mean,
like I said, I can't make him.
No, I understand that. I don't have a factual basis. And if you want to have the prosecutor come in to see if he wants to voir dire your client.
They felt that the fact that he threw it in that area where she was, that was an assault.
Well, an area, I need to know like the proximity of that area. So
near the dresser, correct?
Yeah, I would say within 2 feet.
And she had one of your children in her hands, correct?
Yeah, she was holding her 3-year-old daughter.
All right, and you threw it, and it got within what, a foot of her or so?
Yeah, my back was turned because I was packing a bag to go to my dad's.
Did it bounce off and hit her? Isn't that what she said? Or?
That's, I believe, what she said.
can we get the prosecutor? Gordon, can you have the prosecutor come in, please? And Mr. Pruitt, we're at the voir dire stage, and based upon the voir dire that's occurred so far, the court has not heard a factual basis by which to accept the plea. So would the people like to voir dire Mr. Pruitt as to the factual basis? What the court has heard is that there is a ring tossed at the dresser, and Miss Pruitt was in the area of the dresser. And then the court also heard that Mr. Pruitt's back was turned and he just threw it at the dresser. So I don't know what all of your discussions were. I don't know the information you know. So, would that be accurate, counsel, as far as what the voir dire has been so far?
Yeah, basically, that there was an argument and that, she requested a divorce. He threw his ring in the area where she was near the dresser.
Okay, I can go from there.
Thank you.
And so, sir, would you say that a reasonable person would feel in fear of that? I understand it may have not struck her, but would a reasonable person have been put in fear from the manner that was displayed with throwing of the ring?
Yeah, I could understand that.
Okay. The court will accept the plea as knowing, voluntary, and factually accurate. The court will accept your plea. And the court will order bond and conditions are continued. You're going to get your next steps, sir, over at probation. And you will receive your information regarding your pre-sentence interview, your pre-sentence interview date, as well as your sentencing date. Let me also just ask a question. So I know this question is for counsel, whether it's Mr. Hyder or Mr. Mohammed. Has the phone been turned back on? Because the court had originally ordered a GPS tether for Mr. Pruitt, and Mr. Pruitt was unable to comply with that court order because the phone had been turned off by Ms. Pruitt. That was what was stated on the record on October 23rd, correct?
That's correct, Your Honor, and I believe Ms. Pruitt is in the courtroom. My client, Mr. Pruitt, has tried many times he's contacted the phone company, and because she exercises control over the account, she won't authorize turning on the phone. So, and then again, Your Honor, as I indicated, I know you don't have jurisdiction over her. It's been 3 weeks. He still hasn't seen his children. Counsel represented to me that she said he hasn't attempted to contact her to.
She's not allowed to contact.
No, but he has been allowed to, through a third party, contact and request, which he's done numerous occasions, and she refuses. And I've been told that she's afraid that he won't give the kids back, and that's just not true. He just wants to see his children, and I know you don't have jurisdiction over it, but I wanted to make that record, because that's what's been reported to me.
Okay,
Judge,
thank
if I
you.
may respond.
Yes.
So I did have an opportunity to speak with the complaining witness, and she's indicated to me that the defendant has had contact with her. However, it was not in regards to actually wanting to see the kids. Not just that, since the last hearing, there's been some developments, which is actually why I would like to renew my motion. At the previous hearing, I requested for the court to impose an alcohol tether on the defendant because I believe he posed a danger based off of his previous conviction and what's been relayed to me by the complaining witness. Since then, I've been informed that the defendant had gone to the school where the complaining witness was with her child. He was
Unbeknownst to him.
Well, hold on, let Mr. Mohammed finish, please.
He was intoxicated. He drove there, and there was contact between the defendant.
Stop interrupting, please.
I was informed that he drove there. How he got there, I guess that's a question for an investigation to be done. But that's what I was informed of, or that's what's being assumed. But he was intoxicated, is what I was told, and at that time, there may or may have not been an assault that occurred between another individual, not the complaining witness in this case. And there was contact made between the defendant and the complaining witness. So that's what I've been informed.
What was the contact that's alleged, counsel?
Your Honor, here's the way I understand.
Mr. Haydar, hold on, please, just a moment.
Most of the things I talked about.
Judge, I think I was informed there's multiple things that were said. I think it's best for the complaining witness to present that to the court under oath. I don't think it's appropriate for me to, because I don't want to speculate on what's being said or secondhand knowledge. I have no objection to her informing the court what was said, but what I was told was that he did go to that location at the school. He did have contact with her. He was intoxicated. At least it appeared he was intoxicated. So based on that, I'm not requesting for the court to impose any jail, but I do think that, and I'm going to renew my motion for an alcohol tether because I do think it's appropriate for this specific person considering the circumstances of the case.
Well, I will conduct voir dire of the complaining witness. However, I will also entertain the tether issue. But if your client, if the complaining witness isn't turning the phone back on, then I can't put a tether on. That's as simple as it goes. There needs to be a phone for both alcohol and GPS tether. And I can't do that since she's turned off the phone and she won't turn it back on. So I'm going to voir dire your client, counsel. You can voir dire your client as to the allegations of contact. But at the end of the day, your client, the complaining witness is going to have to turn on the phone for Mr. Hyder's client.
I understand, and Judge, I have no knowledge about the phone, so.
Okay.
As much as I am.
All right. So counsel, I'm going to have you and your client step over to the side for just a moment. Good morning. Please raise your right hand. Do you solemnly swear or affirm testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. And if you can please state and spell your first and last names for the record, please.
It's Gage Pruitt. Geuruitt.
Okay. Thank you. Okay. And Mr. Mohammed, did you want to voir dire the complaining witness?
I can, yes.
Okay.
Ma'am, I'm going to take you back to the day of October 24th, 2025. Did something happen at or near the location of Valade Avenue in the city of Riverview, County of Wayne?
Yes.
And what transpired?
Yep. So I had to pick my daughter up from preschool. During certain times of the month or every other month, you have to volunteer to clean the school. So the school sends out reminders on Facebook for the parent that's responsible for being in that day. I've obviously been by myself, so my mom was with me, and I asked her if she could get Violet while I do my cleaning duties at the school. So my mom's there, I'm there about 15-20 minutes early, and I'm in the bathroom and I'm cleaning, and I start hearing my mom and the teacher yelling, and I could hear Randy screaming, where's Violet? Where's Violet? And so I come out of the bathroom, which is in the back of the school, and I see him tugging on my mom and take Violet and start running out the door. So I go around and go outside of the school, and obviously like my mom and the teacher are trying to come with me because he's clearly intoxicated at this point, fumbling all over himself.
Wait, I'm sorry. How do you say clearly intoxicated?
Another mom had said that he fell out of the car in the street walking up to the school already. And then when I was watching him, I mean, he was visibly intoxicated, meaning like his motor functions were not working properly. So I told my mom and teacher, I just looked at him and I said, call the police. Let me just talk to him. Because at this point he has my daughter and he's taking off down where there's a playscape down there. So he's taking off down to the playscape. And so I'm just trying to talk him through, like, Randy, you just need to stop. The police are coming. You need to give me back Violet. You need to stop doing this. And it was, the cops are coming here to investigate you. You're going to be in a lot of trouble for this. Why are you doing this to me? I still love you. Do you still love me? And at that point, the cops had came and got him for Randy and took him to the side. And I was able to get my daughter and go off the other side.
Okay. Tell me about the phone. Did you turn off his phone?
I did. Yes.
And why aren't you turning it back on?
Right now, there's a business that's connected to my phone line. That's his phone number. I've had a lot of people within the business reaching out to me that their cars are stolen, that Randy's refusing to give them their cars back. I don't want anything of mine associated with this business. I don't want to have to deal with these people asking me where are their cars, that I have all of their car keys when I don't have anything except for my one car. That's it. So for me, I want absolutely nothing to do with the phone line, with the business. I don't want it associated to that account on Turo.
Okay, so then why didn't you just transfer it into his name instead of completely turn it off?
Like the account's under my name.
Right, so why didn't you just transfer it over to an account in his name?
I guess I'm not understanding. Like, he could open up his own account. I just don't want the phone number associated to me.
Okay, so Mr. Hyder, your client can take the phone number and open up his own account.
Well, go ahead, respond.
I have tried on 4 occasions. I have 2 emails on my phone right now to do a port transfer. She has declined every one of them.
Ma'am,
The emails.
Yes,
saying,
I know.
managers-
well, why are you declining? If you don't want it associated with you, why don't you just allow the port transfer? I don't understand. Why would you decline that twice?
I just don't want the number associated. I wanted it completely shut down, and that's,
So then why did you decline it? Why did you decline the port transfer? That would have transferred everything over to him and disassociated it from you. Why did you decline the port transfer?
I just didn't want the phone number to be active anymore.
But you also want a tether for protection.
I do.
You can't have both. You
I
can't have both.
agree.
So you just didn't want the number to be active,
Correct.
okay, to affect his business?
For me not to be associated with the business.
I understand that. If the port is transferred to him, it won't be associated with you.
I'll turn it back on.
Yes, 100%. That has to be occur by 3:00 today so that Mr. Pruitt can have the alcohol tether fixed. That's what we're doing.
Okay.
Mr. Pruitt, thank you very much for coming in, ma'am. So by 3:00, ma'am, you need to, well, let me do this. Let me state this. There's no contact between the two of you. So however you were going about asking for the port transfer previously, do it again. And she's going to accept the port transfer. So long as it's no longer associated with her, which I presume on a port transfer means it's taking the entire account, the number and all, transferred it over to you, and it will be disassociated with Ms. Pruitt,
Yes.
correct? Okay, ma'am. You are not allowed to decline that. All right, now, in the event there's some large amount of money that would be associated with doing that would be attributed to you, then I don't know how that gets resolved, but that will be between counsel. I don't know. What I do know is that the phone needs to be activated so that Mr. Pruitt can go and get that alcohol tether on today. All right, now, Mr. Pruitt, let me be very, very clear. While I don't have jurisdiction over the parenting time and the custody of Violet, counsel, I can understand why apparently there's some concerns by Miss Pruitt that your client's going to not return Violet because he went to the school and took her away from the school, was attempting to take her away from the school. So all I'm saying is this, Mr. Pruitt, right now, the child is with Miss Pruitt, okay? Based upon the restrictions that this court has on from the allegations that occurred that night. I'm not making a determination about parenting time or custody. If you want that determination to be made, you need to file an action in the Third Circuit Court. Until then, the situation is what it is. I cannot order any parenting time, arrangements, times, or otherwise between the two of you with Violet. If there was a pending order, I could address that. There's not. So until such time as there's a pending order, or until such time as the two of you have some type of understanding regarding Violet through a third party, there isn't any parenting time for you.
Right. Your Honor, just so you indicated at the hearing that a third party could contact her regarding parenting time only, and he's attempted to do that. And I guess, what you're telling him is absolutely true. You can enforce it. She's refused to let him see the children. On this particular day, he wasn't aware that she was there at the preschool. He is very involved in that preschool himself. He would oftentimes be the one to pick up his daughter and do the cleaning. So It wasn't like he was trying to see.
And counsel, I can appreciate that. That's why I'm not indicating there's a violation of bond conditions regarding contact. Potentially, there could be an issue regarding consumption of alcohol, which this court ordered you not to have, but we also don't have any type of testing or anything like that. So let me be very, very, very clear, sir. You are going to get that alcohol tether on this afternoon. You're also going to be tested before you get that alcohol tether on. Will there be anything that comes up in your system when you're tested? When's the last time you consumed alcohol?
It's been a while. I just tested at DNA yesterday.
Okay, so counsel, I'm asking this question not because I'm going to then initiate a bond violation against your client. Full transparency, sir. When is the last time you consumed alcohol?
Drink after that day.
No, not after that day, no.
Okay, but you will acknowledge that day was while you were on bond,
Yes, Your Honor.
and you're not allowed to consume alcohol.
Yes, Your Honor.
Do you know what that means?
Do not consume.
Yeah, you disregarded the court order and consumed. So that is why I'm ordering you to have an alcohol tether, right?
Yes.
I know that that was also raised previously. And the reason why you don't have it is because you don't have there's not a way that that can occur because you don't have your cell phone. That's all going to be rectified today. So then you will have that alcohol tether on today.
Your Honor, I did speak with Mr. Muhammad, and he told me he was going to bring up the issue. I really didn't have an objection based on what we know, but he also indicated he didn't feel, and I don't feel that the GPS would be necessary as well.
No, it's only the alcohol tether.
Okay.
The court removed the GPS tether portion of it last time based upon the lack of a telephone service. But in this regard, the court's going to technically amend its prior order from, well, I've already terminated the GPS tether, so I'm adding the alcohol tether.
Thank you.
Okay, and so that court request, sir, you're going to leave here after you go to probation. So presumably you could be there by 1 o'clock, correct?
Well, she would have to have the.
You would be able to, you'd be able to be to the phone store by 1 o'clock.
Yeah, should be, yeah.
Okay, then you can do the port transfer. So then, ma'am, you will have to accept the port transfer, which will then allow you to be over to the facility for the alcohol tether not later than 4 p.m. There's plenty of time for all that to occur,
Yeah, but-
including traffic and travel time.
Right, like, it's just the preconditions for removing her objection, right?
She doesn't have an objection anymore.
No, well, I know she doesn't, but if she waits till 2 o'clock,
I think that Ms. Pruitt's
I hope so.
more focused on your client maintaining sobriety than she is waiting until the last minute to accept the transfer for the port. So that will not be an issue. Because if it is an issue, she could quite frankly be back before the court on a show cause. So
Absolutely.
Your Honor, can I ask one thing?
what is that?
Would it be possible to do the tether tomorrow morning just because I have a ton of work that I have to catch up on?
So I can appreciate that, but no. Ma'am, the moment the the port request is sent to you, accept it. Okay? Okay, thank you. All right, bond and the balance of conditions are continued. And I certainly hope, sir, that you're not going to put your child in that position again, trying to go to the school and take her home. Okay? Not unless there's a Third Circuit Court order that would say otherwise. All right, thank you. Have a good day. All right.
Okay, I think she's trying to set him up because with a DV charge, you can't have primary custody. So I think she's got plans in the works already. And the reason I say that is because nothing touched her. She even said nothing touched her. How can that be DV? I just don't understand it. Words don't make up DV. The only thing is, with the 769.4a status, that's the deferral program. And if he successfully completes probation, the charge goes away, like it was never even there. So in that way, he's protected. Hopefully he can finish probation. But in my opinion, that was the setup. At least that's what it seems like to me, because how can that be a DV charge? I don't understand it. Maybe it's possibly it came close, but he wasn't aiming it at her, and it never touched her. Didn't leave a mark, nothing like that. So how can that be? It's interesting. I just wonder. I think she's trying to set him up. That's my opinion, but anyway, thank you guys so much for watching. I'll see you another time.